Welcome, baby bar applicants, to the Big Bad Baby Bar Review. Welcome aboard. We're going to be talking about question 1 of the June 2020 baby bar exam. Now, it's the first year law students exam for some. Now, the question 1, so we should always start our questions with the call of the question, and that is something that we should do because the call of the question gives us guidance in how the essay unfolds itself and the directions in answering the essay, which is of premier importance. So with that, we should look to the first call of essay 1. What is that? Let's read. What claim or claims can Penny reasonably raise against Mel? What arguments can Mel reasonably make, and what is the likely outcome? Discuss. Call number 2. What claim or claims can Penny reasonably raise against Otto? What arguments can Otto reasonably make, and what is the likely outcome? Discuss. 3. What claim or claims can Penny reasonably raise against Nigel? What arguments can Nigel reasonably make, and what is the likely outcome? Discuss. Right here, we should understand that we're dealing with a claim, not a crime, a claim. So we're in civil law. We're not quite sure yet if this is indeed a contracts question, but I think after we read the call, we'll be able to answer that. I should say this, excuse me, we've already read the call. After we read the facts or from the fact pattern, we will be able to answer that question as to what area of law we're dealing with. So let's read the fact pattern of essay number 1. Mel was late for an important meeting with his supervisor one evening and was driving at least 35 miles an hour on a residential road. The posted speed limit on this road was 30 miles per hour. As Mel rounded a curve in the road, Nigel suddenly backed out of his driveway in front of Mel. Mel's headlights were on, and his lights would have been visible if a driver had looked carefully. To avoid hitting Nigel's car, Mel both braked hard and turned into the center of the street, crossing a yellow no passing line and partially entering the lane of oncoming traffic. Even if he had been going substantially slower, he would have had to take these actions to avoid hitting Nigel. Otto was driving towards Mel while adjusting his car radio. As a result, Otto did not see Mel in time. Had he been attentive, he likely could have avoided an accident. Instead, the two cars collided, left the road, and plowed into Penny, who was walking on the sidewalk. Nigel's car was not touched. Penny was seriously injured. Now, after reading this fact pattern, we should come to understand that we're dealing with torts. We're not dealing with contracts, and obviously we're not dealing with criminal law. So with that, we're going to put down our shopping list. Our shopping list is a checklist of sorts that we start with to help us when we go back and through a second read of our fact pattern, we'll be able to pull out of the facts our issues. So we start out first with intent, negligence, strict liability, products liability, other torts, and third-party issues. Now, right off the bat here, we should understand that these are pretty big issues, okay? And so as we go through a second read, we'll be able to understand that some we can issue spot from the fact pattern and some we'll have to remove. So let's go through that second read now. Mel was late for an important meeting with his supervisor one evening and was driving at least 35 miles an hour on a residential road. The posted speed limit on this road was 30 miles per hour. Well, right there, for us baby bar, excuse me, for us baby bar takers and our applicants, we should understand that this is actually the issue of negligence per se, which fits into and nicely comports with our negligence issue. So we automatically now, under the first call, which we will now set up our first call. Our first call being, we're saying 1, and it's, remember we say our first call is Penny. What claims can Penny reasonably raise against Mel? So it's Penny v. Mel, and something we want to get in the habit of is shorthanding our the names of our parties when we can, because this will help in time management situations where we can easily identify a party and get right to the issue and right to our analysis. Issue number, or I should say this, call number 2 is saying what claim or claims can Penny reasonably raise against Otto. So this is Penny P v. Otto. And we will return to our negligence per se. Thank you for your patience. Now, as to our third call, what claim or claims can Penny reasonably raise against Nigel? And obviously, we have a third call, and with a third party versus party orientation. Now, we should right out of the chute here, we're beginning to understand that Penny is indeed suing 3 particular defendants: Mel, Otto, and Nigel. Right there, we should understand that we have a third party issue. And what would that third party issue be? One plaintiff suing 3 defendants, when potentially those three defendants could be a contributing factor or a substantial factor in bringing about Penny's injuries. Exactly right. Joint and several liability. So we will include that in our analysis here. We will mark that so we don't forget it. Okay, but now back to our promised negligence per se. Negligence per se fits inside of negligence, but we need to finish reading our facts before we jump right into this analysis, because facts are our guide. They are the things that help us issue spot in essence. So let's go right up to our facts and read those. As Mel rounded a curve in the road, let me first begin with the first paragraph. Thank you for your patience. Mel was late for an important meeting with his supervisor one evening and was driving at least 35 miles an hour on a residential road. The posted speed limit on this road was 30 miles per hour. Okay, this is where we see our negligence, and particularly our negligence per se. As Mel rounded a curve in the road, Nigel suddenly backed out of his driveway in front of Mel. Mel's headlights were on, and his lights would have been visible if a driver had looked carefully. The word carefully, what does that tell us about Nigel's case? Or is it Penny's case against Nigel? Exactly. We also have an additional negligence claim against Nigel. To avoid hitting Nigel's car, Mel both braked hard and turned into the center of the street, crossing a yellow no passing line and partially entering the lane of oncoming traffic. At this point again, we have a negligence per se claim against who? Mel. Penny can claim that as the negligence per se that was violated by the speed limit sign brought about also potentially even an additional negligence per se claim that we could talk about under the same header, negligence per se, for Mel crossing a yellow no passing lane or passing line and partially entering the lane of oncoming traffic. That would represent the second negligence per se that we could talk about together under the header negligence per se. Even if he had been going substantially slower, he would have had to take these actions to avoid hitting Nigel. The he here is Mel. Otto was driving towards Mel while adjusting his car radio. As for those who have read fact patterns beforehand, this should immediately scream out to you, this is negligence, okay? And negligence of what type again? Negligence, possibly negligence per se. Maybe not, but most likely this is going to be a breach of a duty rather than negligence per se, because there's no safety statute being brought out in our fact pattern here. As a result, Otto did not see Mel in time. Had he been attentive, again, beating our breach of duty argument, he likely would have avoided an accident. Instead, the two cars collided, left the road, and plowed into Penny, who was walking on the sidewalk. Nigel's car was not touched. Penny was seriously injured. Okay, so let's come down here and start sorting out our issues. Okay, first of all, for Penny v. Mel, we have a negligence claim with a negligence per se major issue. Now we will go into other factors or other elements in negligence, but for right now we just want to make a note of what issues we're dealing with for each particular party orientation. Right here we have a negligence claim that Penny can bring against Otto. Why would that be? Because Otto was, as the fact patterns say, adjusting his car radio and not being attentive. Down here, under Nigel, remember who Nigel was? This is the gentleman backing out. And it with let's see here. Let me see that correctly. Nigel suddenly backed out of his driveway in front of Mel. This is that Nigel. So we have another negligence claim. Now, you might be asking yourself here, wow, we have 3 negligence claims. What does that mean? Are we going to be recycling the same rule statements? Possibly yes to that. What does that mean? We can actually supra or as discussed above a lot of our rule statements. So that's why it's so important to start with a good rule statement so that when we supra or as discussed above, our rule statements that are being referenced to are solid, good rule statements that our bar reviewers will be able to say this person knows their law and has effectively applied it to the facts. Now, down here under negligence, for negligence involving Mel, we should give a rule statement. Here is our rule statement for negligence. Okay, and by the way, do we have intent? We don't want to go too fast here. No, we don't have intent. Do we have negligence? Yep. Do we have strict liability? Nope. Do we have a product liability causing products? Excuse me. Did a product cause the injury, invoking our product's liability claim? No. Now, do we have other torts? Another tort issue, like misrepresentation, nuisance, and so forth? No. Do we have third-party issues? We've already talked about that. That would be joint and several liability, and we'll talk about the 2 accompanying sub-issues that pop up with joint and several liability. So what we have here left over after our shopping list is negligence and third-party issues. Look, this is exactly what we have down here in our rule statement. Now do you see the power of a good shopping list and power of a good checklist? Now we're going to delete our shopping list now so we can start writing. Negligence. Now, defining negligence. Negligence is a what? Negligence is negligence is present when the defendant owes the plaintiff a duty, the defendant has breached that duty, and the defendant, and such breach is the actual and proximate cause of plaintiff's injuries. Okay, now you might be saying to yourself, what are the elements of negligence? And that's why we probably could put an additional statement here. The elements of negligence include duty, breach of duty, actual cause, proximate cause, damages, and damages. Okay, excellent. That is a fantastic rule statement. Great job. Now, as we come down, we're going to first tackle duty. Duty of what? Duty of care. Now, inside of duty of care, we should take the time here to explain what goes into a duty of care template. Now, I might be asking, what do you mean by template? Well, every one of these issues inside of negligence breaks out even further so we can properly address the facts. Now, inside of duty of care, we're going to first go into a general duty. Okay. When you're dealing with general duty, it begins with a reasonable person. We're going to throw down reasonable person. Now, reasonable prudent person is what I would say. And a reasonable prudent who what? Now, if you could, you should start adapting a lot of our facts into our headers. And adapting our facts, we could say, what was Mel engaging in at the time that he possibly breached his duty to Penny? He was driving. So right here we have duty of care, general duty, reasonably prudent driver. Now, what is our rule statement for general duty? Okay, and this is where we're going to talk about under Paul's graph, the Paul's graph case. Under Paul's graph, a general, the Cardozo position states that a duty is owed to all foreseeable plaintiffs in the zone of danger. Say that, we could say the defendant owes a duty to all. See, there we go, right? Take that. Owes. Okay, so let me restate this here. The Cardozo position states that the defendant owes a duty to all foreseeable plaintiffs in the zone of danger. Now, we also want to put in here our Andrews position. Under alternatively, Andrews states that the defendant owes a duty to the world at large. Now, let's take a look here. Here, Mel, or M, we can say M here, owed Penny a duty to act as what? A reasonable, prudent driver. But wait a minute here. This is too conclusory. So we should be adding some facts here to establish our general duty. What is it up here? Let's take a look. We was late for an important meeting with the supervisor one evening and was driving at least 35 miles an hour on a residential road. The posted speed limit sign on his road was 30 miles per hour. As Mel rounded a curve in the road, Nigel suddenly backed out of his driveway in front of Mel. Now, what facts here can indicate that Mel owed Penny a duty to act as a reasonably prudent driver? Well, he should have what? Here, Mel's speeding. Okay, how about this? Let me put it to you like this, because we have the whole chain of events where Mel collides with Otto, or he avoids running into Nigel, colliding with Otto, and then Otto and Mel plow into Penny. This is what we have here, right here. Instead, the two cars left the road and plowed into Penny, who was walking on the sidewalk. Now, you might be asking yourself, what does this mean? Can you please connect all the dots for me? Okay. Well, here's what we're looking at. We're looking at Mel's speeding. Is it just his speeding? No, I really don't think what we're looking at here is his speeding that's going to establish that he created a zone of danger. But you could argue that. So after on second thought, Mel's speeding. Okay, how about this? Mel's Penny was in the zone of danger created by Mel's speeding. And you want to probably put some facts in there. He was going 35 in a posted 30 miles per hour zone. Yes, exactly. Posted speed limit on the road was 30 miles an hour. Penny was here. We're gonna take this and move this over here. Take this out of here. Cut this. Sometimes you might have to go through your work and when you're practicing, go through and try to perfect the way you're going to present things, because on exam day, like we're taking extra time here, we probably would not have this amount of time. But we're teaching ourselves how to write effectively. And when we've accomplished a proficient way of writing effectively, we'll be able to also reach what we call as like working understanding and working knowledge of our application of the facts to our given law. In this instance here, Penny was injured when Mel and Otto collided into Penny. Now, was the collision the zone of danger? Well, Penny will argue what? That Mel's speeding created a zone of danger. Or what you could say that Mel's speeding created a zone of danger, and Penny will argue that she was injured while in this zone of danger. Thus, Penny will argue that Mel owed Penny a duty to act as a reasonably prudent driver. Ta-da! Okay, there we go. And we probably want to bring this down here so we can show our reader that we're observing proper IRAC. So we got I, R, A, and C. Okay, excellent. Now, as we run through this here, because we're probably not going to spend as much time as we can on other issues, I just wanted to show you how to put together, moving. Going, there we go. Okay, proper spelling there. Thank you for your patience. Because we're going to go now into additional detail on other issues. We're probably not going to be able to spend as much time on this particular issue or other issues as we spent on this particular issue. So as we move now into negligence per se, which is what? A special kind of duty. We're going to be looking at three particular factors. The three factors are type of harm, class of plaintiffs, and whether or not there was an excuse. And what do I mean by excuse? Can the defendant raise any particular excuse arguments that would not that would resolve his conflict with the plaintiff? Now, those kind of situations would be emergency-based kind of excuses. Now, down here, when we're saying special duty negligence per se, this is the breach of a safety ordinance. It's a breach of a safety ordinance or statute, and says that a breach of duty, when our duty and breach of duty are present when the particular type of harm is the type of harm prevented against by the statute. The plaintiff is in the class of parties protected. Class of parties protected. And the defendant does not have a viable excuse. Now, the type of harm here, what is the type of harm that you think speeding? Now, you might be asking yourself, whoa, time out here. Where is the negligence per se in the first place? Okay, well, it's actually in the posted speed sign right here. They posted speed limit right here. This posted speed limit. The posted speed limit was put there for a safety ordinance. When that was violated, when Mel went 35, rather than observing the proper speed limit of 30 miles per hour, that essentially put into motion our negligence per se. And we're going to have in our analysis go through and establish whether or not that claim will survive proper analysis. Now, when we're looking at the first claim, the type of harm, what's our type of harm? When Mel and Otto plowed into Penny, is that the type of harm prevented against by the statute? In other words, does the automobile collision have to be with another automobile, or can it be with a pedestrian on the sidewalk in a residential area? Well, that would definitely, both of those possibly could be situations that the statute was intended to encompass. But here in this instance, we have a two cars colliding into each other, which ultimately those two cars plowed into Penny. And when that type of injury, is that the type of injury prevented against by the speed limit sign? I think so, and I think you could make a viable argument for that. So you come down here, and I would say yes to that Penny being plowed into was the type of harm prevented against by the statute. Now the big question here, was Penny in a class of parties protected? What does that mean? A class of parties contemplated by the legislature when they made this particular statute safety ordinance. Was Penny in a class of parties that they were thinking about when they made this law? Well, let's take a look. What activity is Mel engaged in? He is driving a car. Now, driving a car, and let's take a look here. I believe it's a residential area of the street. So we could argue that technically he could very well be in a residential area. Let me see here. On a residential road. The residential road. We want to pay attention to our facts here because that residential road is going to give us a clue that Penny indeed is in a class of parties protected. Why? Because Mel or any other driver who's not observing the speed limit could very well run into Penny. Why? Because Penny is a pedestrian on the sidewalk. Right here it says that she was walking on the sidewalk, and she was walking on the sidewalk that was very near where Mel could have very well been speeding, and therefore, as we talked about, she's also in the zone of danger. And flowing from that, was she in the class of parties protected by this particular statute? Absolutely yes. So you could argue that yes, indeed, that Penny was in a class of parties protected by the statute. Now, on to the next one. Can Mel argue to Penny, hey, Penny, I was late for an important meeting with my supervisor this evening. I needed to go 5 miles per hour over the speed limit. No, that is not a viable excuse. What Mel could have done, he could have stopped his car, maybe called his supervisor ahead of time, telling the supervisor that he would be late and not be able to meet at that particular designated time, and therefore Mel could have easily kept within the 30 miles per hour speed limit, and this whole thing possibly could have been avoided. Now, down here, therefore, is there a viable excuse that Mel can bring? No. Okay. So, do we have a possible, even if the general duty, which would be a reasonably prudent driver, would not work, do we have also a special duty, negligence per se argument that Penny can bring? Absolutely yes. Now, after we've established our duties, we're going to move to a breach of duty discussion. Now, breach of duty is technically when a party, the defendant, has breached their standard of care, breached essentially their duty to act as a reasonably prudent driver, or in the instance of the negligence per se situation, has breached the argument that they are breached their obligation to remain safe while driving on a road by observing the posted speed sign. Now, breach of duty here, there are two major arguments that could be raised. We got the learned hand calculus, and we also have res ipsa loquitur. Well, we don't have a thing speaks for itself situation here. We know exactly what caused Penny's injuries. It was Otto and Mel colliding or plowing into Penny. So we don't have res ipsa loquitur. Do we have a learned hand calculus situation here? In other words, do we have the situation where we have to analyze the risk versus the utility? Absolutely. So we're gonna put in here is learned hand, and the calculation here is B is less than P times L. Now, essentially in breach of duty, what we're trying to find is whether or not the defendant acted unreasonable. Now, Penny will argue that this is the learned hand calculus is meant to produce is this particular analysis, that Mel has indeed breached his duty to Penny when Mel's the burden to have acted differently. In other words, could he have observed the speed limit sign? Could he have acted more reasonable than he did, or acted in any reasonable fashion than he did? Is that less than the probability of what? Colliding into Penny times the liability or severity that an automobile colliding into a person might cause them injury? Yes, I believe this would definitely be a very, very easy case for an easy element for Penny to win and establish, because Penny could say that Mel could have indeed acted more reasonable by calling ahead to a supervisor and observed the posted speed limit, which in the situation we might have been dealing with a very dark and evening situation. In other words, there would have been a need for paying closer attention to driving and observing, even closer observance of reasonable, prudent driving. Now, what is it that Penny's going to say here? That Mel could have acted in a more reasonable manner. We want to supply that reasonable manner, just like we said, calling ahead to his supervisor, maybe telling the supervisor that he would be late, maybe paying closer attention to the fact that it was evening, and the fact that he needed to maybe even pay an extra special attention to those evening conditions. And the fact, too, that he was in a residential area, we could also add to our analysis here. So do we have a breach of duty argument that Penny could win very easily? Absolutely. Now, after our breach of duty has been established, that Penny can establish a breach of duty, we're going to look to what is called as actual cause. And this is often called as factual cause. We're going to begin with the first kind of actual cause, our first test for actual cause, which is called the but-for test. In the but-for test, we're essentially saying that but for the defendant's conduct, the plaintiff would not have been injured. In other words, they are the factual cause of the plaintiff's injury. Now, is Penny going to be able to say this? Let's take this for a spin. When Penny was let's put it this way. But for Mel's, or Penny will argue that but for Mel not observing the posted speed limit sign, or observing the 35 mile an hour designation on a residential road, would Mel have not collided into Penny and causing Penny to suffer injury? Well, that is a very interesting argument, because there are so many factors and so many so many events that come between Mel's not observing those posted, or the speed area, this posted speed in this particular residential road area, and ultimately colliding into Otto and running into Penny. Because we have Mel, number one, trying to safely navigate around Nigel, who's backing up. Number two, we have Mel then having to go over posted the yellow line and the yellow no passing line, and we also have him then running into Otto, who is driving towards Mel, and then ultimately we have Mel colliding with Penny. Can Penny say that but for Mel's not observing the posted speed limit sign of 35 miles an hour, that Mel would not have collided with Otto? I don't think that Penny would be able to safely argue that. So we have to add an additional test for our actual cause, which would be the substantial factor test. Because also, as we noted beforehand, we have multiple tortfeasors here. We have Mel, we have Otto, and we have Nigel. Now, substantial factor test says that where a defendant is a set of defendants, or a collection of defendants, tortfeasors, I should put it this way, that the plaintiff's injury would not have resulted if not for the plaintiff's, excuse me, let me restate this. Thank you for your patience with me, because this substantial factor can be a tongue twister at times. Whether or not the plaintiff could argue that the defendant is a substantial factor in bringing about the plaintiff's injury. And what is a substantial factor? That the collection of the tortfeasor's conduct represented the totality of the circumstances, or the totality of the events that brought about the plaintiff's injury. And that therefore, if you took out one, you may not have the injury to the plaintiff. Do we have that here? In other words, do we have Mel, who's speeding? Do we have and then do we have Nigel backing out of his driveway? Do we have Otto who's adjusting his radio? Are these all substantial factors that resulted collectively in bringing about Penny's injury? Absolutely yes. So I think even if Penny were unsuccessful in our but-for test analysis, she could safely argue that Mel was an actual cause in bringing about her injury through the substantial factor test, because Penny will argue that Mel's conduct was a substantial factor in bringing about her injury. So I'm going to put a yes on that one. Now, proximate cause is our next causation issue to look at. Under proximate cause, we primarily look at two things. Sometimes the third thing, and I'll talk to you about that here in just a minute. Foreseeability and intervening events. What that third thing I was going to tell you about in foreseeability, even unforeseen situations like a pre-existing condition of a plaintiff that is exacerbated by a particular conduct, a particular course of conduct taken by the defendant, the defendant takes the plaintiff the defendant takes the plaintiff as they find them. So in other words, we don't have a thin skull we would call that a thin skull plaintiff rule. We don't have that here, but I wanted to key that to you so that you understood that sometimes that is present, but in this case we don't have that. Okay, so foreseeability. What is our proximate cause rule statement? Okay, our proximate cause rule statement states that could it be said that the defendant foreseeably knew that their course of conduct could foreseeably cause harm to the plaintiff, and that whether or not intervening events that came between the negligent act and the harm to the plaintiff represented an unforeseen superseding event that would have broken the defendant's chain of causation. Well, let's take a look here. Could Mel foreseeably could Mel could Mel understand that his course of conduct could foreseeably result in harm to Penny? Absolutely. Why do I say that? Back up here to the facts. We always want to stay tight and close to our facts. He can say that he's in a residential road or on a residential road, and what activity is Penny engaging in? Walking on the sidewalk in this residential road. So if Mel were to collide with Mel, trying to avoid running into Nigel, collides with Otto, is it foreseeable that Mel and Otto, might plow into Penny? Absolutely. So it is foreseeable that the course of conduct taken by Mel could result in injury to Penny. So I'm going to put a yes there. Now down under intervening events, let's take a look. This is going to be one of the bigger discussions. We're going to have to sort out is the activity of Nigel backing out of Nigel's driveway an intervening event that was unforeseen by Mel, and thus unforeseen and possibly superseding. Well, we look here and we say, number one, first of all, if we have to keep close to our facts. So if we read the facts tight here, we're looking at this particular fact when we're thinking about this complex question. We're going to say to ourselves, what did the examiners mean when they said even if Mel had been going substantially slower, he would have had to take these actions to avoid hitting Nigel? Well, what they were trying to get us to think about was the fact that even though this was an intervening event, in other words, it came between the negligent act by Mel, the negligent act I think we've established the negligent act could very well be his not observance of the reasonably prudent driver standard by not observing the posted speed limit sign and rounding a curve on the road with that speed and having to react to Nigel. Is there an activity that comes between that conduct and Penny's injury? Absolutely. And what is that conduct? That is Nigel backing out of his driveway. Now, was that unforeseen? I would argue that that's a natural response. Now, think about this. Is it Nigel's backing out that's the natural response that our bar examiners are trying to cue us to? No, it's actually Mel's response, because remember, we're still under the Penny versus Nigel analysis, okay? It's Nigel's response to reacting to it's Mel's response to Nigel backing out of Nigel's driveway, because the bar examiners tell us that even if he had been going substantially slower, he would have had to take these actions to avoid hitting Nigel. That's exactly right. So what they're telling us is that this indeed is a natural response force, and as such, or a normal response force, and as such, we could argue that it is indeed foreseeable, and the first of our intervening events that we could argue would not break our causation. Now, the second intervening event would be Mel's crossing the yellow no passing lane and then going right and colliding into Otto, who didn't see Mel in time. Okay, so is the collision between Otto, or sorry, I should say this, Mel crossing the no passing line and partially entering the lane of oncoming traffic and ultimately resulting in colliding with Otto, a natural response to having responded to Nigel backing out of Nigel's driveway. We could argue that. We could say that this would be what a normal, or I should say this, a reasonable, prudent driver would respond in a normal manner. However, you could make an argument against that he should have maybe taken another course of action. But staying consistent with our facts, we could very well say that indeed this is a normal response force to Nigel backing up, which actually caused Mel to cross the no passing lane and then entering the lane of oncoming traffic and colliding it with Otto, which now, because Mel has collided with Otto, both Otto and Mel, or Mel and Otto, collided with Penny, or plowed into Penny. Now, we've established two particular intervening events. Have any of these intervening events broke our chain of causation? In other words, were they unforeseen? No, we've established that they were indeed foreseeable. Number two, were they normal or natural response forces to Mel having to take a course of action in response to Nigel backing out of his driveway? Absolutely. They're normal, they're natural, they don't represent any kind of superseding intervening event, okay? So we could say that we have intervening events, yes, but nothing to break the causal chain. So no break of causation. So has Penny now, because she's addressed actual cause and proximate cause. Remember, we're going to be going through additional essays where we go into additional analysis and explaining additional analysis, but for this essay, we're just going to go through a overview, okay? Has Penny established actual cause, actual cause and proximate cause, and ultimately established that indeed Mel was a cause of her injury? Absolutely. Now down to damages, and this is a very interesting area. Now, damages can be easily dispatched with, because why am I saying that these could be easily dispatched with? Because Penny the collision of Mel into Otto brought about the two cars colliding, leaving the road and plowing into Penny. Was Penny walking on the side of the road? Yes. And was Penny seriously injured by this collision? Yes. So therefore, there is a recognizable damage. Remember, the two recognizable damages in negligence are personal injury and injury to property. Remember, negligence does not recognize economic damages. It recognizes personal damages to your person, and property damage. And in this case, we have personal damage to Penny. So we have, yes, personal damage. But now we want to even break apart our damages even further. We're going to talk about general damages. Under general damages, and I'll put in parentheses here, these are what we call as non-economic damages. Non-economic damages are damages that in general, every plaintiff who has suffered because of personal damages or personal injury would experience. And these kinds of recognizable topics would include pain and suffering and loss of the ability to enjoy life. And those two more or less are non-economic. Okay, and that's why we call this technically a non-economic remedy or damage. Now, and so Penny would be able to recover if she is successful in her claim against Mel for pain and suffering of being seriously injured and loss of her ability to enjoy life due to that injury. Now, if we go further through our damages analysis, we're going to also spot special damages, and these are economic damages. And these would be things connected with Penny's medical expenses, her out-of-pocket expenses, maybe lost wages, and lost future earnings. So Penny, if she prevails in her claim against Mel, she could indeed be able to recover general damages and special damages. Now, is this where the story ends? Absolutely not. We actually have a set of defenses that Mel can bring against Penny. And under defenses, we're going to first talk about the three recognized defenses for negligence: contributory negligence, comparative negligence, and assumption of the risk. Now, in contributory negligence under the common law was a complete bar to recovery. Now, what technically could represent a contributory negligence situation? It's when the defendant is saying that the plaintiff's course of conduct has what? Well, it has breached a standard of care. Now, what is it that Mel is going to say about Penny when she's walking on the side of the road possibly late in an evening? Because we say late because there was an indication here that there were headlights on. Mel's headlights were on. So this would possibly a time and night that most drivers would not have been able to see Penny easily. So what is it that Mel could argue in a contributory negligence sense against Penny? I mean, she could have breached a standard of care to have acted as a reasonable person would have acted in that same or similar circumstance by maybe having particular clothes on that would have made her easier to see from the road, like yellow designated safety uniforms or anything of that sort that Penny could have been wearing while she was walking on the side of the road. So this is what Mel could raise. Now, remember though, this isn't where contributory negligence ends. There is a plaintiff counter argument as well to this, and we could argue that the defense this really isn't a defense, excuse me, so that this is a last clear chance argument. Goes hand in hand with contributory. What is Penny going to argue? Penny's going to argue that I may have not worn a safety vest or a safety uniform while I was walking late on that evening, but hey, Mel, you were the one that had the last clear chance to avoid the injury, and you did not take that course of conduct. So, Mel, you're the one that is actually at fault. I'm not the one at fault. And that's what the last clear chance doctrine is saying. And can Penny bring this up? Absolutely, she can. Now, the additional defense that Mel may bring is comparative negligence. Remember, there's two types of comparative negligence: pure and modified. In pure comparative negligence jurisdictions, the plaintiff can recover even if they're 99% at fault. So they can recover that 1%. In a modified jurisdiction, depending on what kind of modified jurisdiction, comparative negligence jurisdiction the defendant is in, if they're 50% or greater, they may be barred from recovery. Excuse me, I said defendant. Excuse me, I meant to say plaintiff. That if the plaintiff is at fault for their own injury, 50% or greater, they may be barred from recovery under a modified comparative negligence jurisdiction. California is a pure comparative negligence jurisdiction. So looking at the fault apportionment system that comparative negligence represents, it lessens the harshness of our contributory negligence bar against recovery if the plaintiff is at all at fault for their own harm. The court will apportion the degree of fault between the parties, including Penny, and thus will reduce Penny's recovery by that apportioned degree of fault. And so that's what Mel could argue against Penny, to reduce the amount of recovery that Penny may be able to collect against Mel. Now, the assumption of the risk argument is what Mel is going to say. He's going to say, remember, in assumption of the risk, there's express assumption of the risk and implied. We don't have any written documents embodying an assumption of the risk agreement between Penny and Mel. We have an implied situation between Penny and Mel. And what Mel is going to say about Penny is, Penny, you should have recognized, you should have appreciated that walking along the side of a road may present a risk of being collided with by a car. Well, would Penny in a residential area walking on the side of a road have even been appreciating a risk that two cars colliding would leave the road and plow into her while she was walking on the sidewalk? See, I don't think this is a very strong argument for Mel, but you could argue it, and then you would say possibly that even though Mel may argue that Penny might have appreciated it, the argument that the whole totality of the circumstances were such that Penny would not have appreciated the unfolding of the chain of events that happened, and having the cars leave the road and plowing into her. Therefore, even if Mel were successful in arguing this, that he would, or I should say, excuse me, that Penny would be successful in arguing that she would not have been able to appreciate this, and therefore she would not have assumed such risk, and therefore the assumption of the risk defense would not be an effective defense for Mel. Now, we want to make sure to throw in a conclusion at the end of our discussion, so we don't want to forget that. We want to make sure to put that in there, because we're going to put in our conclusion as to negligence in our conclusion discussion between Penny and Mel. So we want to keep that in our mind's back burner, okay? Because when we come down here to joint and several liability, we don't want to fuse joint and several liability with negligence at all. We want to make sure that we separate the two claims that Penny can bring against Mel in our conclusion. So, but back to joint and several liability. Joint and several liability involves primarily two considerations. Is there contribution and indemnification? Now, you might be asking yourself, what is joint and several liability in the first place before we even talk about contribution and indemnification? Joint and several liability is saying that a collection of tortfeasors represent the parties that brought about, caused, made possible the injury to the plaintiff, and therefore they are jointly and severally liable for the plaintiff's injury, and as such, the plaintiff can recover 100% of the damages that plaintiff is entitled to from one of the many tortfeasors. In this situation, Penny suing Mel, Penny could recover the full amount of her damages against Mel. Now, what is it that Mel, though, can bring against, we'll say, Otto, another tortfeasor, and Nigel, another tortfeasor? Mel may be able to argue contribution. In other words, did Mel contribute in terms of damages to Penny more than his share, his pro rata portion? In other words, his up here under kind of under the same analysis as comparative negligence, his shared fault. In other words, if he were a percentage at fault, did he contribute more than what he is technically liable to penny for? And he can recover that difference, that contribution from the other tortfeasor defendants. And down here under our conclusion, we want to make sure to put in, again, just a reminder, our negligence result, the defenses from the negligence result, and whether or not Mel may be able to argue Penny may be able to argue joint several liability, that she could sue Mel for 100% of the damages, and bringing up Mel's argument that he could possibly argue contribution from the other tortfeasors. Now, when we're talking about Penny and Otto, we're going to now be superating a lot of our rule statement here from negligence. So we're going to say supra or as discussed above. I've seen either one of these, I believe, would work. So I'm just going to put this in quotes for you. Okay. Now, after this, we're going to be going into same set of analysis: general duty, special duty, if there are, breach of duty, actual cause, proximate cause, damages, general damages, special damages, defenses. And we don't want to forget our contribution or contributory negligence, defense, last clear chance, comparative negligence, defense, assumption of the risk, and conclusion. Wow, you might be saying to yourself, this is a lot of area to cover. That's exactly a good observation. When you have three calls of the question, some or most of the time you have what we call as a racehorse, and we have to apportion our time. That's why what we're spending extra time here to teach this, but we would apportion our time in a appropriate time management format in order to address all calls of the question. Now remember, footnote there too, not all calls of the question are created equal. In other words, you might give more time, like we might have given more time to Mel than we gave to Otto and Nigel, or maybe Otto or Nigel than to Mel. Okay? Or maybe Otto or Nigel to Nigel or Mel. You get the idea. So down here under Penny's claim against Otto, we're going to say, as we did with Mel, that it was a reasonable, prudent driver situation. Now, we got to ask ourselves here, Otto, what was Otto engaging in? He was engaging in engaging in driving while adjusting his radio. Okay, so do we have any special duty situations here? Now let's take a look. Do we have a professional? Nope. Do we have a landowner situation? Nope. Do we have any particular innkeeper situations, public utilities, common carrier situations? No, again. So special duties, could it be said that Otto created the peril? I don't see that. I'm looking to see if there's any particular special duty that was owed to Penny by Otto. And see, I don't see that here at all. Even though uh, I don't think there is. I do not see any particular safety statute connected with adjusting the radio. So I would probably delete that special duty argument because we have a general duty argument. And so we come down here under breach of duty. How did Otto breach his duty to Penny? Otto breached his duty to Penny by what? Let's come up here and take a look at the facts again. Staying to our facts and having our facts close at hand is a must. Down here under here, Otto was driving towards Mel while adjusting his radio. That's probably not a very reasonable thing to do. You would definitely agree with that? Good job. Because you're taking your eyes off the road and you're not observing proper, reasonably prudent driving protocol. Now, is that enough then for Otto's conduct of adjusting his radio to be considered unreasonable? Absolutely. So we want to throw that in our analysis, very similar to our Mel analysis, because we're going to borrow the rule statement. We're going to say that the breach of duty was through our learned hand formula, because we're going to supply our calculus formula here. Less than b is less than p times l. Now, did Mel act unreasonable? Absolutely, he did. Now, unreasonable conduct, would that breach our duty of care that would be owed to Penny by Otto? Absolutely. So we have breach of duty here. How could Otto have acted differently? Let's take a look. Are we talking about breach of duty? Oh, all good. Okay. Okay. Excellent. Excellent. Thank you very much. Excellent. All right. Okay. So now, is the learned hand formula going? Oh, keep going. Excellent. Okay. Breach of duty. Learned hand formula. Otto's conduct would be considered unreasonable. What could have Otto have done? Let's go back up to our facts and look at this. Mel or Otto could have possibly pulled over to the side of the road, then adjusted his car radio. Now, because he didn't do this, that would make it unreasonable. But we're trying to point out to our reader, our bar exam grader, that we understand what a creative argument is. Remember, a creative argument is that burden to have acted differently that the learned hand calculus points out. What could Otto have done differently? Like we talked about just a few seconds ago. He could have pulled over to the side of the road. He could have then adjusted his car radio, and then he could have got back on the road and resumed driving. That would have been the reasonable way of doing things. But did Otto do that? No. And that's what makes it unreasonable. And it's that creative use of the facts that your reader is going to appreciate. Now, and the other thing is, what else would point out that Otto may not be paying close attention to the road? The facts tell us, Otto did not see Mel in time. Now, again, even if we had not have seen that, the bar examiners are being very gracious to us by pointing out this. Had he been attentive, he likely would have avoided the accident. Wow. So we could have avoided the accident in the first place by having Otto pulling to the side of the road, then adjusting his car radio, and then resuming driving. So down here under breach of duty for Otto, this is definitely an unreasonable way of doing things that Otto engaged in, unreasonable conduct. And we already pointed out what he could have done differently. Actual cause. Now let's start out with our but-for test and establishing our actual cause or factual cause. But for Otto adjusting the radio, would Penny have been injured how she in and how she was injured. Absolutely. We could argue this in a but-for sense. Why? Because the bar examiners are giving us a fact that deals with this. Look right here. It says right down here, Otto did not see Mel in time. Had he been attentive, he could have avoided the accident. So had he pulled to the side of the road like we talked about, adjusted the radio, and then resumed, that this particular injury to Penny would not have occurred. So we could say, but for Mel's conduct, Penny would not have been injured in how she was injured. So the but-for test would work for our Otto situation. Now, proximate cause. Is it foreseeable that if you're not paying, if a driver not paying attention to the road and not paying attention to the road, how? By adjusting the radio, would not see Mel coming from crossing the lane and coming in the oncoming traffic? Yes, very foreseeable that Otto would collide with Mel. Now, was there any intervening events that might break the chain of Otto's causation? See, that we're looking at now, we're looking at the point in time when Otto was adjusting his car radio, acting unreasonable. That was the negligent act. Anything that comes between that and Penny being injured is what we would call an intervening event. And what would that be? Absolutely right. Mel coming across the no passing line, partially entering the lane of oncoming traffic, and colliding with Otto. And you could even say that the two cars, when they collided leaving the road, could be an additional intervening event. But I ask you, are those natural intervening events? In other words, are they natural responses to what? Otto adjusting his car radio. Absolutely, you could say that. So they're normal, natural, foreseeable events. They would not represent unforeseen, superseding, intervening events that would break our defendant's causal chain. Therefore, and we want to make sure to point out those events that we just talked about. After pointing out those events and indicating that those indeed are foreseeable, normal reactions to the situation as it unfolded from the time of Otto adjusting his radio to the time that Penny was plowed into. Nothing in there would have superseded the chain and broke the chain of causation from Otto's negligence to Penny's injury. So no break. So saying yes, foreseeable, and no break in chain, or I should say causation. Okay, so we could say indeed that Otto was a cause in bringing about Penny's injury, and Penny could argue that. Now, under our general damages argument, we talked about this before. This is our non-economic. Can Penny, if she prevails against Otto, can she claim pain and suffering and loss of the ability to enjoy life from Otto? Absolutely yes. Under special damages, could she recover medical expenses, out-of-pocket expenses, loss of the ability lost wages and lost future earnings from Otto? Absolutely yes as well. Now, in a very similar way, Otto could say that Penny was not observing proper standard of care by walking late at night. As exactly right, we could supra as well that analysis from above and save ourselves a lot of time. If you have time to add some facts in when you supra analysis, you could very well direct. Yeah, you could say direct. You could say that it was direct too. Yeah, for proximate cause, addressing the question about an approximate cause, whether that was a direct causal chain. Well, there is only one thing to consider here is if Did Mel adjusting his radio while driving bring about the injury to Penny? You could argue that that could have directly caused that, but see, I think we're overlooking the fact that it was Mel who crossed the no passing lane. The facts, yes, that it was Mel using the facts here. Let's go back up to the facts. That it was Mel who was crossing the no passing line and partially entering the lane of oncoming traffic that we have to take into consideration. And because we have that intervening event, we could argue that even though if we were to take the stance of it being a that Mel, so I say this, Otto adjusting his car radio directly caused injury to Penny. If you would take that stance, we would not be able to bring in any intervening events, because by the doctrine of direct causation, there are no intervening events. There's just that negligent act and then the injury to the plaintiff. But we have an intervening event. We have Mel crossing the no passing lane and partially entering the lane of oncoming traffic. So we could argue that that was an intervening event that would take our direct argument into an indirect argument analysis. And that's where I see it. I see it as an indirect argument that we would indeed be able to argue from the facts that had Otto been attentive, he would have likely avoided the accident. It was also Mel who crossed the line and partially entered the lane of oncoming traffic. So if you take the direct analysis, you could argue that maybe it was Otto who was adjusting his car radio who ultimately then brought about the injury to Penny by way of colliding with Mel. Or you could say in an indirect way, in an indirect causation analysis, that Otto, while adjusting his car radio, would have been able to see Mel in time to have avoided the whole injury in the first place, and therefore the Mel crossing the no passing lane and partially entering the lane of oncoming traffic could have been an intervening event, and then we could ask ourselves if that's a natural, normal, foreseeable intervening event, which would not break the causal chain the causal chain from Otto's negligent act to Penny's injury. So this is why proximate cause can be quite a very involved topic, a very involved issue in our discussion. Now down to defenses, contributory negligence, very much a supra in our analysis. Oh yes, you could say so indirect. You could say so indirect, and so we could put up here, we could say indirect. Yeah, we could say indirect. Now down here under defenses, what is Otto going to say about Penny? We talked about this a few moments ago, that Otto is going to borrow an argument from Mel, and that's going to say, Penny, you should have understood that the standard of care owed by pedestrians to drivers is that you would wear safety vests or safety uniforms while walking late on evenings, so that drivers can identify you on the sidewalk. Okay. Now, even if that is an argument that Otto could raise against Penny could say again, like she said against Mel, Otto, you had the last clear chance to avoid this injury in the first place by not adjusting your radio, and therefore had you not adjusted your radio, as the facts point out, let's go back up to the facts and take a look at this again. As the bar examiners pointed out, had he been attentive, he could have avoided the accident. Therefore, Penny could argue that Otto had the last clear chance to avoid the accident in the first place by not driving while adjusting his radio, and therefore it's Otto who is the one who is truly at fault here. Now, under the defense, the additional defense of comparative negligence, which we talked about before, lessens the harshness of the contributory negligence bar against enforceability if the plaintiff is at any degree at fault for their own injury. we are going to say that in a pure comparative negligence jurisdiction, as California is, pure and modified. California is a pure comparative negligence jurisdiction. That Mel will be able to, or Otto will be able to argue that Penny's recovery should be reduced by her, Penny's, apportioned degree of fault. Now, under the defense, very similar argument to Mel that Otto's going to say, Penny, you assume the risk by walking on the sidewalk without proper without proper safety vest or some kind of visibility uniform, that you assume the risk that you might get hit. Well, this is not a very sound argument because we're in a residential area, like we pointed out before, and she's on a sidewalk walking. Yes, it's on an evening and late evening, but would she be able to appreciate the risk that walking late in the evening that she might get plowed into by two oncoming cars that have collided into each other and plowed into her? No, I don't think that we could argue. He's going to bring that up, but I don't think that's going to be an effective argument for Otto. So we go to our conclusion, and under our conclusion is that Penny may be able to argue negligence against Otto, and she may be able to recover the special or general and special damages against Otto. Now, down under for Nigel, we're going to, Nigel is remember, going back up to our facts to refresh our memory again, is who is Nigel? Nigel is the one that suddenly backed out of his driveway in front of Mel. Okay, now borrowing the same analysis from up above, we're going to go, because now remember, we're getting it as we're writing this essay, we're getting to the end of our essay. And as we get to the end of our essay, like we said, we can super a lot of analysis. We can bring in a lot of facts, but we're going to be shortening our facts as well. And so we're going to be saying that we're going to be shortening up our facts here. Oh, copy and paste, that's exactly right. Thank you for pointing that out. We want to make sure we can copy and paste our analysis and copy and paste our template. So as we fill out our outline, and yes, as we go through additional essays, we will take the time to teach how to copy and paste templates into the additional calls of the question, like we could have down here under Nigel, and saved ourselves a lot of time. And so when we get to Nigel, there's going to be that would have helped us a great deal on Nigel, because all we would have had to do at that point is just put down supra analysis as discussed above, that kind of language, and then put in the appropriate fact. Now under Nigel here, we have, I'm just going to throw in, we've got general duty, special duty. We don't have any special duty. We have to make that determination up, and then actual cause, or sorry, breach of duty, actual cause, proximate cause, general damages, special damages, and we're going to remember we would have probably already copy and pasted this, the defense of contributory negligence from Otto or Mel down to this as well. You guys can see now that the copy and paste tool is a very effective writing tool and is very helpful. Last clear chance. Defense assumption of the risk. Okay, and then we're going to make sure to throw in our conclusion. Okay, now this argument for Nigel is going to be very similar to Otto and Mel, all the way down to our breach of duty. We're going to say under breach of duty that Nigel breached his duty by not attending to proper backing up protocol, now, or backing up conduct. What are we saying here? Let's go back to the facts to get a good analysis started. Nigel suddenly backed out of his driveway in front of Mel. Now, Mel's headlights were on, and his lights would have been visible if a driver had looked carefully. Now, let's ask ourselves here: was Nigel looking carefully when he was backing up? Well, let's go back and look at the facts again. Nigel suddenly backed out of his driveway. Suddenly? The word "suddenly" there, he wasn't paying careful attention. And the facts are pointing to this. And number two, supra rule and application. Exactly, you'd supra the rule and application and apply the facts that we're pointing out here from Mel or from Otto. Now, his lights would have been visible if a driver had looked carefully. Now, to avoid Nigel's car, Mel braked hard and turned into the center of the street. Now, remember, we also know that even if Mel had been going slower, he would have had to take these actions to avoid hitting Nigel. Because why is that so important even now? Is we're looking to see that Nigel suddenly backing out of his driveway was not representative of reasonable conduct, and therefore he breached his duty to Penny to act in a reasonable manner. What could Nigel have done? Well, let's take a look. We're dealing with one evening. We're dealing with a situation involving a need for car headlights, so it's probably dark outside. Nigel should have, instead of suddenly backing out of his driveway, he should have paid more careful attention, maybe slowly backed out in order for him to then see Mel coming and appropriately have navigated his car out of his driveway instead of suddenly backing out of the driveway. So was the course of conduct engaged in by Nigel an unreasonable course of conduct? Absolutely. Therefore, Nigel breached his duty to Penny. And that's what I would have put down under breach of duty argument. Now, we know that his general duty argument would have been a reasonably prudent driver, how a reasonably prudent driver would have acted in backing up out of their driveway. He breached that duty like we talked about. But for him not suddenly coming out of his driveway without observing reasonable conduct, it is very likely that but for that, Penny would not have been injured, because remember, let me go back up here and take a look at this. I think the facts probably argue against what I just said. We'll take a look here. It said that he would have had to take these actions to avoid hitting Nigel. So what is that saying? Is Nigel a but-for factor, or is Nigel a but-for of Penny's injury? Well, we might be able to argue that, but I think the stronger argument, like Mel's situation, I think we could say that Nigel is a substantial factor. We would throw that in there, substantial factor test. I think we could argue if the but-for test did not work for Penny, she could easily argue and prevail in saying that Nigel was a substantial factor in bringing about her injury, because had Nigel not suddenly backed out of his driveway, there's a strong possibility that Mel would have safely gotten around Nigel. But I don't want to invent any facts. Okay, so we don't want to invent facts. It's something we want to avoid. So with that being said, we want to stick close to the facts and say that simply that Nigel was a substantial factor in bringing about Penny's injury. Okay, and therefore, as a result, Penny could argue that Nigel's is a actual cause of Penny's injury. Now down here under proximate cause, was it foreseeable that Mel reacted to Nigel's suddenly backing up out of his driveway? Absolutely. Was that response a normal response? Absolutely. What is it that both of those are brought about by in terms of facts? Remember, again, staying close to our facts are important. It's an important procedure in our writing process. Down here, Mel here, let me put this here. Even if he had been going slower, he, Mel, would have had to take these actions to avoid hitting Nigel. So it is foreseeable that Nigel can't say that Mel's speeding 5 miles over the posted speed limit in a residential road superseded or unforeseeably superseded and broke the chains of causation, because even if Mel had been observing or going substantially slower in terms of taking that corner or that curve in the road, rounding that curve in the road is what the facts state. Mel, would have had to take these actions to avoid hitting Nigel anyway. So what is it we're saying? That there was no break in the chain of causation. So our proximate cause analysis is intact. Penny can say that Nigel is a proximate cause of her injury, and that Mel's response to Nigel was a foreseeable reaction in that it was an intervening event. We could argue that in fact, Penny could argue that Nigel was a cause in bringing about her injury. Now, down here under general damages, again, non-economic damages, general damages are non-economic damages, meaning the pain and suffering argument, the loss of the ability to enjoy life argument would also apply to Nigel. Special damages, out-of-pocket medical expenses, lost wages, lost future earnings, again, still applicable. The defense, Nigel is going to borrow from the same analysis like we talked about, super rule and application. And again, we're going to say, Penny's going to say, even if I did not observe proper safety during late evening hours by walking with a safety vest on, that the last clear chance here argument is still intact, because Penny could say to Nigel, you, Nigel, had the last clear chance to avoid this situation in the first place by not suddenly coming out of your driveway so fast and not observing reasonable driving protocol. Now, down here under defense of comparative negligence, again, we could argue that in a pure comparative negligence jurisdiction, of which California is, Nigel will be able to argue that Penny's recovery will be reduced by her apportioned degree of fault. And under the defense of assumption of risk, which will again not work for Nigel even, because there is nothing about walking on a sidewalk in a residential area late in the evening. That would give Penny an indication that her conduct, the conduct she was voluntarily engaging in, represented a risk that she was assuming. The risk being that she would be plowed into by two colliding cars. Again, putting our conclusion down concerning this collision event down as that Penny will be successful in her argument, potentially will likely be successful in her argument against Nigel, and the defenses do not appear to be a viable argument for Nigel. So with that, I'm going to say adieu, and I thank you so much for tuning in to our podcast. We're going to be having more broadcasts as things as I start getting more fluent with the Google Docs and YouTube Studio and podcasting. So I thank you so much for tuning in, and I thank you so much for absolutely being excited about taking the first year law students exam, and I wish you the best of luck on that exam. Thank you so much for tuning in.